On the record, in the matter of Codeine Sowers versus Nicole Garvey, file number is 22-036325. Counsel appearance.
You guys gonna come to the table? Or not?
Good afternoon, Your Honor. Brian Lum on behalf of plaintiff.
Felicity Tell on behalf of the defendant.
Today's the date and time that was set for a motion for attorney's fees. Okay, Mr. Lum, you filed a motion for attorney's fees and costs, indicating or requesting order to be granted in the amount of $6,674 for attorney's fees,
Yes, Your Honor.
$24 for parking, and $20 for a motion. That's correct? This was a land forfeiture case, as argued by the counsel for the defendant, very similar to an eviction. Why did it cost almost $7,000?
Well, Your Honor, this took over 6 months. When our first hearing was scheduled, the day before the hearing, defense counsel filed a jury demand, which extended the time. I prepared for a jury trial.
You prepared for a jury trial?
I did. I was
When?
preparing for a jury trial, 2 weeks before the jury trial. Jury trial was adjourned right before the actual hearing. So I did prepare multiple times.
When did we set this for jury trial?
It was first set for jury trial.
For a jury trial? What date?
The jury trial was going to be on March 8th. But it was turned into a bench trial.
It was adjourned and then it was
It was adjourned when?
then the
I don't have a note of it being adjourned.
and then the jury demand was waived. The weekend before the trial was to occur.
I'm looking for your statement that you said it was originally set for jury trial on what date? March 8th. What day do we have the hearing was March 20th? I'm sorry? I don't think we adjourned the jury trial or the trial date. Is that what you're seeing in JIS?
It was converted into a bench trial.
You never adjourned a jury trial.
Your Honor, the trial was never adjourned. It was
Converted.
Yeah.
You didn't prep for trial more than one time. You had one trial date.
We had a trial date before that.
No, we had one trial date. It just was converted from jury trial to bench trial.
Well, originally it was scheduled for a bench trial. So I prepared for that back.
When was it set up?
In January, I believe. In January.
We had a hearing on January 10th.
I believe the January 10th was adjourned.
Well, you're the one billing, so you should know exactly what you're billing for, correct? Not you believe. You appeared for court, it was this many hours. You appeared for, that's not what you provided. We appeared for court here. There was a notice to appear generated back in December. On the 9th of January, Ms. Tell filed an answer in jury demand. Jury trial was originally scheduled to be on the 8th of March at 8:15 in the morning. That's the date that we had to try.
It was originally scheduled for a bench trial in January.
We never scheduled a bench trial in January. We had a pretrial on this case, the standard. Then we
Pretrial.
had a hearing. We never had no bench trial or jury trial scheduled in this matter in January.
There was a pretrial December 21st,
Correct.
and then it was scheduled
There was a hearing scheduled.
January 10th. It was the hearing scheduled.
Correct. The January 9th is when we got the jury demand. So you did not appear for a hearing on the 10th. Once we got a jury demand, the hearing was removed from the docket.
I don't believe I was notified of that until the 10th.
You weren't notified that there was a jury demand?
No hearing.
When did you serve him with the jury, your answering jury demand?
I can double check for sure, but I would have mailed the jury demand on the 9th.
It was mailed on the 9th. I wouldn't have received it until the 10th at the earliest.
But I can check and make sure, see if I indeed mailed or emailed a copy on that date.
Okay, so what you're saying is from the time that you appeared on this land forfeiture for the first pretrial, it took you a whole nother set of preparation to come to the next hearing date, is what you're saying.
So I prepared for the hearing on the 10th, and then I
Prepared how?
viewed the file and went through that.
And how many hours did that take you?
So it took me, I had an hour and a half on the 9th and 10th.
The 9th and the 10th?
Yeah.
An hour and a half total?
Correct.
Ma'am, can I help you? Because why are you huffing?
My back hurts.
You can have a seat.
Oh, I didn't know that.
Oh, you absolutely can have a
Oh,
seat.
thank you. That helps.
Okay. Okay, so you, on the 9th and the 10th, you said it took you an hour and a half to review the file. Okay, there was a jury trial that was scheduled to be on the 8th, but I see where, as of the 3rd, it was converted of March. So when did you prep for a jury trial?
The week prior.
You were noticed then that it was going to be a bench trial a week prior.
I don't know, Your Honor, I believe the Friday before. March 3rd, I was notified that they were withdrawing jury demand.
Okay. And how many hours did it take you to prep for trial? On this land contract forfeiture, that the trial took a total of 30 minutes.
I have 3.5 hours of working on jury instructions and reviewing the file. Miss Tills.
I'm not paying for jury instructions. You were notified well in advance that this was being converted.
Still submitted a significant amount of exhibits to review. So I was trying to.
Okay, review of exhibits. How long did it take you to review the exhibits?
I don't have that broken out specifically.
We had to work back and forth. You had to get my number to thing. And we went back and forth.
You don't know how many hours just to tell you what you did?
No, I just don't have it broken out specifically for exhibit review. I have 3.5 hours for trial prep.
3.5 hours for trial prep total, you're saying? On a land contract case, which is similar to an eviction, it took you 30 minutes to make a very basic argument? Is what you're telling me? This your first land contract case?
No, Your Honor,
Oh, how many land contract cases have you done?
I don't know off the top of my head.
But many, haven't you?
That's right.
You know how to do a land contract case, correct? So it didn't take you, you didn't have to go research how to do a land contract case, look up new law for this, correct?
I didn't have to look up new law, no, but the defendant provided a separate land contract that they said was the original.
Right, which took,
Terms.
because the court reviewed that, it took me 2 seconds to review it, and within those 2 seconds, I was able to identify the exact differences from the one that you submitted. Didn't take me 3.5 hours to look at it.
She also submitted voluminous receipts and other items I had to go through.
The receipts that are here in the file for what was supposedly paid?
Yes, ma'am.
Okay, so it's the same receipts that you probably would have received in your answer?
They were the same receipts, but they were the same exhibits that we submitted at trial were the same exhibits that we submitted to the court with our answer.
But, and you already reviewed that because you had that before your trial date. You already billed for that.
Trying to make everything add up.
$6,000, almost $7,000 for this land contract. There's no way that's in good faith.
And that's the amount of time I spent on here, Honor.
Okay, well, I'm not granting it. You're gonna have to give a reasonable amount of time that it took you to defend or to this case that you brought for a land contract when the trial took at max 30 minutes.
We were here all day. We didn't know when our trial was gonna be called.
Your trial could have been called all that earlier, but you all wanted to go back and forth. That wasn't the court's title. It still was held all day on that case. She had more than one trial. I asked you which one to go first. You wanted the other one to go first.
Well, you can still go first, but
I don't think she cared which one went first. I thought that was you.
I'm sure my client wanted to go first.
Ms. Till, did you want to respond to his motion for $6,000 some odd dollars?
I believe my arguments would be similar in that this is a case very similar to an eviction and a foreclosure case where basically you just have to prove the contract, prove the amount owed, prove that there was a violation. In those cases, there is at max a $75 attorney fee expended, even though I'm sure many attorneys in foreclosure and eviction cases also bill many more hours than $75 worth. That's still the max allowed in those cases. This is a very similar type of procedure. This was only a 30-minute hearing. I understand that there's some preparations that must be allowed for, but not $7,000 worth. And many of the entries in this billing statement are for hour-long conversations. There's at least 3 entries for conversations over an hour long, one of which was just for our request of an adjournment. I had to go on medical leave, and so there's a conversation for requesting an adjournment that takes almost an hour on 224. So a lot of these preparations, I mean, I understand you do have to call your clients. I understand you have to explain some things, but I don't think that my client should be billed and should bear the expense for that.
Mr. Long, you said that you spent 28.4 hours on this case.
Over 6 months.
I don't care how long the case was waiting in court. I want to know why would it take someone with a P number P72194, which means you've been in practice for some time. You've done, I'm sure, hundreds of evictions and land contracts. And this is a case that went to trial by bench trial with very minimal exhibits and a very basic argument. Why it would take you 30 hours to prepare and litigate this matter. I'm denying your motion because I don't find it to be in good faith. I do believe that you spent some time, obviously, litigating and preparing. It's not 28 hours, though. Sorry, ma'am, are you getting half of this? Are you getting half of these
I
attorney's
have
fees?
to pay the fees.
Okay, let him, you don't get to just decide that what he should be billing. He has to, in good faith, represent to the court what he billed, not try to get you out of paying what you owe. That's not what the purpose of this is. So I find what you're doing to be counterproductive to what his responsibilities are under with his bar license, okay? You all had plenty of time to discuss the billing before he filed this. There was ample time for the motion to be filed. I'm sure he discussed to you what happened. For you to keep going back and forth with him before the court as to what he should be trying to get payment for is inappropriate.
That's not what I'm trying to do.
Well, then I need you to be quiet while we deal with the court matter, okay? I'm not granting the motion for 28.4 hours. I will give you half of that, because I think that's reasonable. I don't think 28.4 hours is reasonable under the circumstances. And I think even half of that is more than generous. And you're billing at an hourly rate of $275,
$235, Your Honor.
$235. Attorney's fees in the amount of $3,370, will be granted. Plus your request for parking, and there was one other thing,
Motion fees.
and the motion fee for $20. That's the order of the court. Any additional matters for the record?
1,307.
3337.